Sharon Michaels. I'm an attorney based in Houston, Texas. My undergraduate degree was from Northwestern University, where I was a major in Medill School of Journalism and Political Science. Following that, I subsequently moved to Houston, Texas to pursue my law degree at the University of Houston Law Center. It was a wonderful experience, excellent program. And upon completion of that, I graduated magna cum laude, and then I went to interview with the First Court of Appeals as a briefing attorney. And I was selected as a briefing attorney by Justice James Warren. It was an excellent experience because we got to hear very complex appellate arguments, both civil and criminal cases at that time. And our function there was basically to review the briefs of both appellate counsels and then do independent case research and then actually do a draft of what the appellate court opinion would be by our judge for his or her obvious revisions and changes and discussions. So it was an excellent learning opportunity, and I stayed there almost 2 years. And after that, I went into private practice. Originally, I was an attorney on a contract basis with the Resolution Trust Corporation. Those of you that remember with all the decline with the savings and loans, it was a very interesting experience. We did a lot of workouts. I was responsible for pursuing claims on behalf of the federal government, sometimes in the bankruptcy court. Many times we did workouts, and the idea was to salvage what assets we could, recover as much income as we could, and allow the savings and loans that could be recapitalized to do so, and the homeowners that sometimes could qualify to actually modify their loans and go on, and others we had to actually sadly foreclose and then recover those assets. So that was that experience. And then after that, I continued doing civil and family court litigation here again, always in Texas, Harris County mostly. And as time passed, I developed a very strong probate practice, which led me into doing a great deal of drafting of wills and ultimately trusts. And that now is really the focus of my practice: trust, estate planning, and probate. And I find it very gratifying, and it's very challenging. And it's also very rewarding because you actually are helping people to carry out sometimes what their life vision is, to protect their heirs, sometimes to make arrangements for what they want to do with their assets for charitable organizations and other specific bequests in that nature. So the beginning part of my presentation here today is regarding the wills and testamentary trusts and the key provisions and functions. And I did also attach, which I'm sure you have in your materials, an Exhibit A, which is the preliminary clauses for a simple will, and then also a will with a trust. That's the other exhibit. So there's 2 exhibits to that. So at the beginning of this discussion, my focus will be to discuss when it is appropriate to use what is commonly referred to as a simple will or a more complex kind of estate planning document. Generally, it's the clients that come in and say, oh, I only need a simple will, just very, very simple. And of course, sometimes they have the goal of minimizing their attorney's fees, and they think, well, if I just say it's going to be a very simple will, obviously the attorney's fees will be less, and I won't have to concentrate and think about it too much, and it'll be quickly drafted, and at least I've got it done. But as the attorney, you really need to specifically sit down, especially if it's a married couple, to talk with both of them, or if it's a single person with that person, to really determine if a simple will is even appropriate under the circumstances. And many, many times it is not. I would say it's probably easier to think about the times when it's not appropriate. But first of all, I'll tell you what the major factors that I'm looking for that would justify a simple will. It would be appropriate if the testator or couple, if it's the 2 testators, only have just a few beneficiaries, maybe 1 to 3, all within the same family structure. Have an estate probably with only 1 piece of homestead real estate, not multiple pieces of real estate scattered over multiple jurisdictions, hopefully within the state of Texas, and a very limited number of specific bequests. And if it fits that scenario, at least you were justified in thinking, yes, this is probably a situation that could fit the nature of a simple will. But even then, the inquiry doesn't really stop there. Those are just the major things you should be thinking about and talking about with your clients in that initial consultation. And at the initial consultation, that is when I always say to them, I really do not just want to do a Zoom call if at all possible. I really would like you both to come into the office, or a single person into my office, and really see what your objectives are, what your specific circumstances are. And then we can discuss whether you need a more complex will or just our simple will. And then beyond that is even a trust, something that you want to consider. Many times a trust is appropriate, but that's a much more complex undertaking. So if they just wanted to be talking about having their will and the ancillary documents, such as healthcare power of attorney, financial power of attorney, which are all statutory forms within the state of Texas, HIPAA releases. And HIPAA release is very important to have because of the now confidentiality of medical records and communications. And even if it's a very close family member, an adult child or a nephew, and this person is suddenly hospitalized or incapacitated, if they're not listed on a durable healthcare power of attorney and your former client is so incapacitated, maybe not even conscious, where they can say, yes, I do want to be able to communicate with this person, and I want you as the treating physicians, feel free to give medical information to this person or this family member or close friend. But without those documents, it just will not happen. Maybe they could go to court if it's a really complex situation and they need to be able to communicate with the physicians directly, but that's going to be a much more onerous and expensive proceeding. So the financial power of attorney is equally important because many people have not designated, especially if they're single, who would pay their bills if, God forbid, they become involved in a serious auto accident or a serious surgery where they're going to have to be recuperating for a period of time. Who is going to be able to sign checks on their behalf or send electronic payments? Again, these are factors they have to really consider who they would trust to make those determinations for them. In Texas, we can do it either where it arises immediately when they sign the power of attorney, or, which is generally what I do, I make it only effective upon the client becoming either temporarily or permanently physically or so mentally incapacitated that they're not able to make their own financial decisions and make these payments and do whatever they need to do, file tax returns even if necessary. So I usually make it what we call a springing power of attorney. So in other words, it only springs into power when the circumstances necessitate. And I always point out to the clients also, if they wish it to be this way, that if they do recover, hopefully, and then can resume their own capacity to pay bills and make financial decisions, the document provides that they can immediately have the power to resume their own capacity and deal with their own finances. And the agent who was acting on their behalf then no longer is authorized to do so, because it's only when the condition is that they are so either physically or mentally incapacitated that they cannot go ahead to do these actions on their own. If they recover, which hopefully many of them do, and I've had that situation arise, but it's a great comfort to them to know that the mortgage payments are being made, that deposits are being made to their accounts. The doctors can be apprised of what the healthcare power of attorney, particularly we have the situation in Texas where the durable healthcare power of attorney, you can indicate if my condition is really, truly irreversible, and even despite best medical efforts, I'm never going to have a complete recovery. And choices, do I want to be kept in that irreversible condition on a machine with no prospect of recovery, or should I be kept comfortable, given all necessary medical care to be comfortable, but to be allowed to pass if that is indeed what the prognosis is. And actually, in all these years that I have, and I don't even know how many hundreds of medical powers of attorney and directives that I've done, I have never seen anyone actually take that option where they want to be left in an irreversible condition. I may eventually have that client, and which is fine, but Up to now, I have never had that. So again, this really argues, I think, for the fact that it is good for people to have these documents in place just so they know that their wishes are going to be followed, and that you're not going to have a situation where the physicians aren't sure what the person would have wanted and the hospital's not sure, and then it ends up, sometimes it's a nature of litigation and having a judge try to discern what the person's wishes truly would have been. So this planning is very, very important. Other circumstances I was going to discuss, which is in my paper, when a simple will, and sometimes it's the easiest way to think about it that way, when it is not appropriate. I would say it's certainly not appropriate if the testator has ownership interests in a business with multiple partners or shareholders, because then you're not dealing just with their particular individual asset. You're dealing with a business entity where there's competing interests and they're sharing ownership with other people. Another circumstance can be certainly if the two testators, if it's a married couple, but one or both have children from other marriages or relationships. The recommended procedure, of course, on that is if they're all in agreement, is to treat each child, whether stepchild, adopted child, or child from other relationships, equally between the parties. But sometimes that is not the wishes of the parties, and you do have to sit down and talk with both of them, not just take it from the one, but truly they are either willing to say that the children of this particular marriage may receive a more of a bequest, a larger bequest, or certain properties that the other children might not share in. Generally, we try to make it equitable because you're much less likely to have any kind of a will contest if all the children, whether adopted, a prior relationship, a prior marriage, stepchildren, are treated equally. You're actually then benefiting, I think, the family by sustaining a good relationship, a working relationship. And I have many situations lately, I think because marriage and divorces are so much more common than years ago, that actually the blended families are becoming very prevalent. And actually, with some time and effort on all the parties, it seems to be working out quite well. So if you can encourage your clients to take that viewpoint, you can point out to them, otherwise, if your beneficiaries, God forbid, one or both of you are passed, you're much less likely to have probate litigation, which can become quite ugly, quite expensive, and probably not in either one of the testator's true wishes. I don't think too many people would want to expose any of the heirs to that kind of situation. So again, if they have a blended family, the documents are going to be more complex because you're going to have to make it very clear that it's not drafting by omission, that you meant to say that everyone would be treated equally, but it just doesn't appear either way. And then it's going to be subject to either a court challenge or interpretation of the executor or executors under the will. What really did this document mean, and how am I supposed to carry out my duties as an executor or executrix? Also, another complicating factor, which is somewhat more common today because I think of the prevalence of drug usage and those kind of issues, and sometimes alcohol abuse as well, that one or more of the potential beneficiaries may not have the capacity, or at least presently have the capacity, in the event of one or both of the testators being deceased, to be able to manage those assets on their own. And again, this requires tact on the part of you as the attorney. You have to inquire, are all your children, stepchildren, whoever we're dealing with in this will as potential beneficiaries, are they going to be able to deal with whatever share of the assets that you're going to have divided among them? And sometimes that's a difficult discussion because, especially if it's one party's child but not the other, sometimes a parent doesn't want to feel almost like they're being disloyal by admitting that, no, probably my son or my daughter either just isn't financially astute or very immature, or as other had maybe some drug issues or psychological issues. And, then we have to have that discussion. Is this likely to be just a very temporary thing? With the passage maybe of some time, rather than providing that everyone takes equally when they're 21 years or older? Maturity doesn't just coincide with the chronological age. It may be that for the certain beneficiaries that you want to actually provide, that they get it in stages. Maybe sometimes I've suggested 30, 35, and 40. You can do it that way in stages. And that way they acquire more acumen, financial acumen, they acquire more life experience. They're much less likely, especially if you're dealing with a 21-year-old that may suddenly be dating and thinks they're madly in love and want to take their inheritance and travel immediately with the new person in their life, and not consider, whether that's something that would really be appropriate over the long term. So those are all the kind of situations that you do have to discuss at length with your proposed clients that are thinking about even drawing what could have been a simple will, but probably is not under those circumstances. And there's also the personalities of the testator to consider, or testators. Some individuals want to include very specific bequests, and they can have very convoluted bequests that require certain conditions be met. And if those aren't met for this beneficiary, then other beneficiaries may come in and receive those distributions or get a larger share. And there may be all kinds of conditions and circumstances that may have to be met for or maybe even go into an entirely different group of heirs. These circumstances not only can it be difficult as far as the drafting, but also as the attorney working with the client or clients, the testators, you may want to really talk with them and say, the more you try to control in this manner and not be equitable among all your heirs, or what your goals are for those heirs, that they're either going to try to contest the will or have it modified judicially, which is always a possibility. The clearer the documents are, the more definitive the language is, the less likely you are going to have some kind of a proceeding in the court document as to what really the testators meant. The clients also many times want to, I had one situation where she had no children, no spouse, but animals. She had multiple animals, and that's certainly understandable. She loved animals, loved her cats and a couple of dogs, but the degree in which she was trying to actually mandate the care that would be provided to these animals, and she was going to set up a trust fund individually and then have the caretaker be able to administer all the needs and expenses and everything covered for these pets. In the end, she actually could not find individuals willing to devote that kind of time and effort, so we had to take a much more simplified approach. The preliminary clauses under a Texas will, first of all, it must say the full legal name of the testator or testators, their county of residence within the state of Texas, that they are intending and have intended to revoke any prior wills, and that they also intend to dispose of all the property within their estate that they're aware of. The next paragraph, usually in a Texas will, which I had attached as a exhibit to my paper, describes the marital status of the testator, whether there are children or grandchildren, whether there are adopted children or stepchildren. And again, specificity is very important. And if they do intend to disinherit a child, which I certainly don't ever encourage, but it can be under certain circumstances, and if that's the case, then they need to explicitly state, and you do as the drafter of the will, that they are specifically intending to disinherit that child. Because otherwise, the heir of the child that is not given any kind of inheritance or bequest can certainly make the argument for a probate judge that it was just an error of omission, that you as the attorney or that the testator themselves thought that they'd made provision for that child or children, and somehow it just didn't get into the document. So sometimes, even though it may sound callous, but actually if they really, really intend to disinherit children, stepchildren, biological children, adopted children, they need to say, for reasons perhaps known only to me, I do intend not to make any bequest to this child of mine. They can state a reason. Sometimes it's better not to go into too many details. They can just evidence the intent to disinherit and not to provide a bequest for those children or grandchildren. Next, usually in the Texas will, you provide that all funeral and medical expenses are considered priority and to be paid out of the estate. And of course, taxes, both federal income taxes and property taxes, out of the residue of the estate as soon as they can conveniently be computed. That last return does have to be, tax return has to be filed on behalf of the decedent. And so that can take some time, depending on how good they were about maintaining their financial records. Even if a married couple, sometimes one has always handled all the finances, and the other surviving spouse, it may take some time to gather the records, even sufficient to be able to allow a CPA to do that final return. And then also, then the next thing in the Texas will, it provides that real property and personal property be distributed by the executor to the heirs with the timing of such as determined by the discretion of the executor or executrix. It's quite a responsibility as far as being the executor or executrix, because not only do you have to get the will filed for admission to probate within 4 years of the death, there's also the other documentations that need to be done. That, as I say, the final tax return needs to be filed as soon as possible. Usually we try to do it within a year if possible. And then also there can be a recitation of the survival as far as beneficiaries. Most of the time we say if the estate is going to pass strictly from one spouse to the other, that they have survived their spouse by longer than 30 days or 60 days. And all those samples are attached to my paper. A next provision that we need to discuss and to think about greatly is what to do with tangible personal property, bequests and gifts. This is something that's a very significant task for the attorney, because many times people have generally thought, you know, what would happen to the house or what would happen maybe to some specific family heirlooms. But beyond that, they really haven't given too much thought as to what will happen with personal property. Some people are very concerned about that. And of course, if it's a married couple, generally they'll just provide that everything passed to their surviving spouse, maybe with the exception of specific bequests that would be more enjoyed by another relative. For example, if the husband's passing, maybe he would want to leave some sporting equipment to his sons or grandsons, or conversely, the wife, she may want to leave specific jewelry to some daughters, granddaughters, great nieces, that kind of situation. Other than that, the people can provide the specific bequests be spelled out in the will, which the court will normally always honor. And you, as the if you're handling the estate on behalf of the decedent, you will make sure that those bequests be honored and that they be turned over, the property, specific property, as soon as the will has been admitted to probate and the letters of testamentary, debtor's testamentary have been issued to either the surviving spouse or surviving eldest child, whomever the will indicated should be the executor or executrix of the estate. Some of these requests can be non-conditional, just outright, these things go to this person, these things go to that person. Other times it's conditional, depending on if the specific person or persons that you've listed have outlived the decedent, and then in that case, these items go to this person. Other times, if it's a share of a class of gifts, then you may want to specify that there can be agreement or equal division between a couple of the heirs that are specifically named to receive those items. And you can provide that if one heir does not survive, then the remaining heir would receive those specific items of personal property. Or if it's a group, that then they can either decide between themselves, if it's more cost effective to do it that way, let them decide between themselves, how they're going to divide up furniture, for example, or perhaps how they're going to divide up jewelry, if it's a couple of daughters, or firearms, maybe if it's a couple of sons or daughters, it depends. But then after that, you can also provide, if it's more cost effective and the heirs don't really want to deal with too much of these complexities, just provide that everything within the house be actually be the subject of a public sale, an auction, and the proceeds be divided equally among the heirs. And many times, especially when people have been married for many years, decades, they haven't really considered how much they've accumulated over a lifetime. I usually encourage that as far as vehicles and boats, that they be the nature of specific bequests. In the first place, you can't really say, well, you could, I suppose, that one heir can have use of a car for a certain number of months and then someone else have it. So that would not be very, very workable. So it's either decide vehicles, certain ones to this child, certain ones to that heir or grandchild if they're older, or just provide that all the vehicles be sold and the proceeds divided in whatever manner the decedent would have wanted in the will, and that's what you list. Other times, also something to be aware of and really talk with the clients. They may not have really thought about what will happen with their, if they have musical instruments or family photographs or heirlooms. How are those going to be treated? Are those going to be going to specific heirs? And if that heir rejects the gift or doesn't even want to take the responsibility of maintaining it, and particularly if they have to maintain insurance on it, they may not want to. So what happens then? And if the bequest fails, does it go to another class of beneficiaries under the will, or should it just all be then managed by the executor or executrix, and if they have co-executors, and just decide, what are we going to do now? Allow the people just to pick equally among a rotating group, or just put it up for a sale. There's also whether certain beneficiaries have the physical space and time to maintain items in the condition that's envisioned by the testator. This is particularly true if you're talking about horses. I've had quite a number of cases in Texas where the parties or party owns livestock or horses, and they have the idea that, oh, I think my friend they enjoy going riding sometimes, but would they really want the responsibility of paying for the horses to be maintained and fed and groomed? That may be just something that's way beyond what they would have envisioned. Yes, they might have enjoyed occasionally riding with their friend, but to actually take that responsibility long term. So again, you really need to think, okay, if this bequest is not wanted or rejected by the potential beneficiary or beneficiaries, what happens next? What would you be more comfortable? So you need to have that discussion. Also, with property subject to a lien, such as vehicles, the will can provide that the bequest pass subject to the lien, or the will can provide that the executor have the right to use the funds of the estate to pay off the lien, and then the vehicle can pass directly to the beneficiary. And sometimes that's the best way, because then you don't have the situation of having to deal with a secured creditor and maybe a beneficiary that just doesn't have the means immediately to be maintaining the car insurance and making payments, because it may be some time before the estate can actually be settled to that point. So it may be better to provide in the will that any vehicle notes be retired, paid off, and then at that point, the probate proceeding can provide then that those specified beneficiaries can take possession of the boat or the vehicles or whatever it is. Usually most people try to divide personal property as soon as possible because there's always a possibility, if personal property is maintained in a private residence or the former household or even a former business property, that the items may be stolen or damaged or lost or not maintained over time as the executor would want, or that the original testator would have envisioned. So it may be best that those items be determined to be passed quickly upon the will being admitted to probate and the executor taking their oath and be granted letters testamentary. It also is important with regard to personal property to sufficiently describe the items so that everyone is aware what exactly are they talking about. I've had situations sometimes where they'll say the oil paintings that are in the living room. Well, it turns out they forgot, they remodeled the house, and maybe what was in the living room had paintings, but now there's some sculptures, but no paintings. So the paintings may now be upstairs in another room. And then you get into what was the intent. So again, specificity, if these are items that are that valuable and that beloved, then a little more time to describe them so the executor is comfortable that they're actually fulfilling the wishes of the testator. You also sometimes have the situation where it seems very unlikely to the person making the will, but they think, oh, of course, my intended beneficiaries will want these items. They may not. They may feel, again, it's too expensive, or they don't have the space to take these items in. So in that case, it's best to provide in the will. If the items are rejected by the initial beneficiary, does it pass to other people? Should it be donated to a charity? Should it just be sold with the rest of the items of the estate, the tangible estate, and then the rest of the proceeds divided as the will provides? Real estate provisions are even sometimes more complicated because of the fact, depending on whether the real estate is owned as a homestead, does it have a note on it, is it paid for, and whether it's going to pass without restriction. Usually when you're dealing with a married couple, most of the times those will provisions provide that the surviving spouse, certainly under Texas law anyway, would have the right to continue to occupy the homestead, but also usually that they entirely inherit the interest in that former homestead of the couple. Usually it's required without any kind of restriction or requiring any additional payments. The will can provide, if there's sufficient money, as far as the testators are both concerned, that upon the death of one or both, one of them, that the mortgage be paid off entirely so that the surviving spouse be able to just occupy the home with having to just pay utilities and property taxes and insurance. And that may be enough of a burden. Whether the spouses, whether you're dealing with a married couple or a single testator, the estate planning should consider whether other relatives or a significant other should be awarded the house, or should the house be sold and the proceeds divided in accord with their testamentary scheme. It may be it's a difficult conversation sometimes, but to have with the testators as to, all right, now, if your spouse passes and this is what we think the income potentially from upon death, the surviving spouse is going to have, is there going to be sufficient money to maintain the house, to pay the mortgage, to pay the property taxes? And property taxes in Texas can be quite high. So that is a discussion to have. And again, as I say, it may be as wise to provide that if there's enough cash in the estate, that prepay the mortgage, and that way the surviving spouse will just maintain it. Also, if the property is to be sold, and sometimes certainly if it's a single person, they may want to provide in their will that the real estate be sold upon their passing. And as soon as the letters testamentary have been issued, that a sale be conducted. And if it's been provided in the will that the property be sold, and that this is something that needs to be conducted in accord with the will and the provisions that are approved by the court and the probate court when the will is admitted to probate, its title is going to pass much more easily if there's a title policy in place and there's no issue then as to how that real estate is to be handled when the only surviving spouse has passed. For non-homestead realty, that can run the gamut to a single interest in a business property. If, for example, one of the testators had some business real estate, not owned by a partnership, not part of a company, but just a small either land itself for the business or just the assets of the business itself with the furniture and the physical equipment belonging to the business. Again, that becomes necessary to discuss with your client what is the intent. If one spouse that was running the business passes away, would the intent be to try to sell the business? Would it be to try to, if there's adult children or grandchildren sufficiently mature or other relatives, would they want to take over the operation of the business? Do they have some employee that is trustworthy and that has really managed the business for them for a great number of years? Would they want to continue running the business but have that person be paid even more of a salary to take over the business that was run previously by the decedent? If there's a joint interest, if it's a partnership or a limited liability company, hopefully you can have the discussion as to whether or not there's sufficient life insurance that could then be used to buy out the interest of the decedent, and the other business owner or owners could maintain the business without there being any undue complications. If it's
Sharon,
not
there was a question. Someone wanted to know if you pay off the home and lose the interest deduction. If you were to pay off the home, would you lose the interest deduction?
Yeah, that is certainly possible. But again, with paying off the home, usually the interest deduction is not a major factor. It's sometimes more important for the financial stability of the remaining spouse that the home be paid off so that they're not financially feeling too impaired. And certainly going to be able to, after the property tax deduction, could be just as valuable, if not more valuable, than the interest deduction. It seems like that's going to be increased soon anyway. So they can certainly still take deductions for the property taxes. And again, it depends on the way that the two spouses, if you're representing a married couple, is it their wish that their surviving spouse be able to live comfortably and not have to worry about keeping up timely with mortgage payments. And it may be much more worthwhile to handle it that way. But that's a very good question. Then the next topic is the fiduciary powers and appointments. And this is regarding who's to be appointed with regard to what's required under the type of will that you're drafting on behalf of these clients. As again, I was referring earlier, there may either be incapacitated other heirs, children, grandchildren with special needs, or just perhaps drug usage or alcohol abuse. Then in that case, rather than leaving something outright as a bequest to such individuals, it may be indeed the best interest and probably the parents' overall wish that the will provide that in that event a guardian of the estate or a trustee be appointed, be set forth in the will, that that person be charged with the responsibility of maintaining either the income or the asset for the benefit of the person under some kind of disability. And of course, then again, you need to also talk with the client. Is this a situation that may improve over time? Is this a temporary disability? Or is it maybe just temporary immaturity on the part of the heirs you're talking about? Is there a possibility that they won't need a trustee as enough time passes? It may be they need a trustee when they're under 25, but not later when they are handling their own affairs. So those are, again, frank discussions. Both people in the marriage may not agree initially, so that's something that really has to be sorted out between them, if possible at all, as to how that's best to be maintained for the interest of those beneficiaries. There can be a distinction also under Texas law between guardian of the person and guardian of the property. Guardian of the property is usually someone that is more adept at handling financial considerations, home maintenance or real estate maintenance, dealing with other kinds of improvements that need to be made to the property to maintain the property's value. Guardian of the person, as opposed to that, is much more involved with seeing that if it's an heir that is either disabled or under a temporary disability, that their medical needs are met, that they're receiving appropriate care, whether it be psychological or physical, that they are being maintained in a safe home environment, whether that be rental, whether that be with some other member of the family, if that's appropriate, or a group home if that's appropriate. So guardian of the person and guardian of the estate are quite different roles. Sometimes people are much more gifted to be a guardian of the person, whereas another heir is maybe the business person, and they're much more adept at being the guardian of the property of the estate. And as I say, also, changing circumstances of the heirs is certainly always a possibility. So the more you can build some flexibility into your will and or trust, if you're drafting a trust for them, the more you can provide some flexibility so that as circumstances may warrant, that perhaps you can provide that if the parties all agree as a family that this is now how we're going to handle this, if there isn't that kind of agreement, then either you can follow the specific provisions that the original testators wanted, or if it's really become a bone of dissension, the surviving heirs, one or more of them, may actually then seek guidance from a court as to how these issues are to be resolved. But again, the more you can put forth the thought and fairness and openness between the heirs, the less likely you are to be having a convoluted, contested court proceeding, which will really eat up so much of the cash of the estate. If you're dealing with a ward that is either under a physical or mental disability, or do that because of drug usage or other kinds of inappropriate behavior, it certainly may be as well to put in the document that is a possibility that the trust may be maintained on behalf of the ward, or the will provide a testimony of trust for that heir, but that the circumstances may be reevaluated over time. Conditions can change, people can change. Hopefully, if it's due to some specific life event or immaturity or some experimentation with drugs, that perhaps their situation can be reevaluated by at least two medical professionals and make that determination that no, indeed, they are actually getting much more, having the ability to be able to deal with their own assets and their own life decisions. And the will could provide guidelines even as to what those criteria could be, and whether then the former minor or the former disabled person might be awarded at least some portion of the assets or the income outright, maintaining some maybe in trust, but at least allowing more specific disbursements that they can handle themselves as they're acquiring the financial experience to do so. My paper also sets forth what Texas requires as far as a will execution. The requirements are fairly straightforward and under Texas law. Certainly the requirement is that the testator appear and sign the will in the presence of a notary and at least two disinterested witnesses. And by disinterested, it means not having any kind of bequest, being a subject of a bequest in the will, because that would make them an interested witness. So they need to be two disinterested witnesses. They need to be familiar with the testator, and they're comfortable that the testator understands the contents of the will. The witnesses themselves must be over 18 years of age, of sound mind, and be willing to, because sometimes it does become necessary, if there's ever a contest to the will, that they'd be willing to, if they have to appear in a probate court and state, yes, I did see the testator, who acknowledged that this was their final will, that they understood the contents of it, that they wished to revoke any prior wills, and they're doing this freely, and they appeared to be of sound mind, and they were over 18, and it was before me, and they willingly signed the will in my presence, in the presence of the second witness and the notary. And those are the requirements. Texas does recognize what we call holographic wills, which are wills entirely in the handwriting of the testator. Some states do not, many do. I was, as an attorney, strongly discouraged that. Not that people cannot state forth what their general testamentary scheme is and what they would want to have their major bequest to which people and what, for example, a house or car or vehicles, that kind of thing. But the problem is, in the first place, many times they don't realize a holographic will must be entirely in their handwriting. It can't have any scribbles by anyone else. Sometimes I've even seen people with their holographic will, they'll line through it and then at a later date, start writing in other little notes, attach little Post-it notes. Sometimes part of the will gets torn, part of a signature may be missing, and even a random writing. Texas courts have ruled sometimes that even a random writing on the will may invalidate it, because the judge may not be sure what was the intent of that little note. What did that mean? Was that intending to do it with the whole document, or was it just a minor change? And the requirements are that it be certain, and if the court is not convinced that it was entirely in that person's name and in their own handwriting and no other writings by anyone else, that it will not be granted to probate. There is also the requirement then also that there be two disinterested persons, and again, no kind of a family relationship where they're hoping to get a bequest under the will, that they have to be two disinterested witnesses then to come to court to testify that they were familiar enough with the testator and the testator's handwriting that they are willing to come to court to testify that this is absolutely the will handwritten by the testator. The other problem is with a holographic will, sometimes it's very, very difficult to ascertain whether the will actually meant this. Descriptions of property may be very incomplete. The phrasing that a person uses may not be readily understood by everyone. It may be not sufficiently clear as to exactly what they meant when they said they were bequeathing this to this person. They may not even give full names of the people that they're intending to give this inheritance to. They may just refer to it as my nephew. And if there's more than one nephew, where does that leave things? They also may certainly not list any addresses, and that can become a problem, because if they have a holographic will done maybe 10, 15 years before, and they have the full name of the person but no address, with our mobile society, it can be very, very difficult to even be able to locate who those beneficiaries are. So because of the fact that it's so really the requirement to have a will be validly accepted in the state of Texas, just a notary and two witnesses, it is so much more practical, so much more less likely to result with actions to declare the will invalid, that I certainly would not recommend a holographic will. So that's probably, I think, what most attorneys would say. And regard to the documents that I supplied with this paper, the first exhibit is Exhibit A, which is the preliminary clauses for a simple will. And it sets forth, as I talked about, that they're of sound mind and the resident of the county and the state of Texas, and that they are disaffirming any other prior will, whatever their marital status is, whether they have children, whether they have stepchildren, that the identity of the family and heirs. And then again, payment of expenses and how those are to be handled under the will and how property is to be disposed. Exhibit B is for the disposition of the estate, and that gives sample ideas of how you do sample bequests and gifts. And example C is a sample will with a trust provisions in the will. So those are the exhibits. And now I think it's time for us to move on to my next topic, which is legal ethics and considerations. The first section under this topic of legal ethics and considerations concerns attorney fees and client trust accounts. It's under the requirement of the Texas Code of Professional Responsibility that unearned attorney's fees be maintained in a financial institution which provides for the maintenance of an IOLTA account, and that be in the name of the licensed attorney. And every year, in fact, when you come to renew your state bar license, you have to certify either that you have no responsibility to maintain a trust account because you do not ever take unearned fees and you do not ever take contingent fees. Very few people can, quite frankly, make that assertion. So most people indeed do have to declare to the State Bar of Texas that they are maintaining an IOLTA account as the State Bar requires, and further that will hold the client funds that are not earned, And also then they have to set forth the name of the financial institution and the IOLTA account number and where that bank or institution is located. Every now and then we have the argument by some attorneys that they only take retainers where it specifies in the retainer agreement that they're non-refundable. And then the argument is made by that attorney, well, because it's non-refundable, I do not have to maintain it in a trust account because it's mine. I'm never going to give it back. So why should I put it in a trust account? Well, there's a number of problems with that argument. In the first place, even if the fee is non-refundable, it has not been earned because just the minute the client signs the check and hands it to you and signs the retainer agreement that says it's non-refundable, those fees are not earned. If it turns out the client completely changes their mind and says, you know what, I did want to hire you to draft a will, but now I've been thinking about it, and I think I have a friend that's an attorney, then they're not even going to charge me anything, or I don't even know if I'm clear yet on what my scheme for disposition of my estate is yet, so I just want to call this off. And please, I want my fees returned. Well, if you try to make the argument that's non-refundable, but you've provided no services at all because you couldn't, you've only just signed the agreement with the client, I do not think that would be a very good situation to have to argue before a grievance committee that you do not have to return the fees, even though you did no work on that case, but it said it was non-refundable. And if it is refundable, then it should be maintained in a trust account, which is the whole requirement for the IOLTA account in the state of Texas. The other problem sometimes with non-refundable fee agreements is that the attorney can be really compromised if, when they get into the case, they think, that amount that I said was non-refundable and that I did receive really was not sufficient to compensate for all my time and effort, and I'm running up some court costs or other costs on the case that I didn't anticipate. So I really think the terms of this retainer agreement should be changed and additional fees should be charged, and then that I can get the additional funds from the client. Well, if that situation arises, certainly the attorney has to have an IOLTA account because they're already changing the terms of the agreement, which is a problem ethically itself. But even if it's after full discussion with the client and maybe even having the client consult with a third-party attorney that does conclude that, yes, the client is willing to enter a new fee agreement, even if that's shown, those fees then are certainly need to be deposited into an IOLTA account as required by the state bar. And that is the easiest way to deal with that situation. It is the most ethical way to deal with that situation. And also, under the requirements of the state bar and the IOLTA account, fees and reimbursement costs can only be returned or withdrawn by the attorney when the fees are actually earned and the costs have been incurred. If there is a dispute between the client and the attorney as to whether the fees were actually earned, whether, for example, the attorney says, well, I spent 5 hours at $350 an hour, and that's the amount that I've withdrawn from that amount that you put on deposit with me, and the client says, I don't think there's any way you could spend 5 hours doing this kind of work. I mean, I've seen other attorneys before, and 2 or 3 hours is certainly the max, and you've withdrawn 5 hours and I didn't approve it. So in that case, if the client makes that complaint, you as the attorney are required to leave those funds remaining in that IOLTA account until the dispute be resolved, either between yourself and the client directly, or between, if they get another attorney, whether the new attorney can then intervene and try to work out some agreement as to how those fees should be released or paid at all to you. And if not, sometimes it even has to go before a grievance committee to decide whether it was rightful that you withdrew some of the money without the client's prior approval, and indeed without even showing that much of the work was even done on the case. When the fees are disputed in the IOLTA account, then nothing must be withdrawn until it's resolved. The best practice is to send out monthly statements stating the amount of fees that you anticipate that you have earned, and show what other costs you've incurred, and the hourly basis, if that's the basis of your fees being charged, and the application of the balance to then the trust funds remaining in the account, and what your proposed withdrawal of those funds will be. And if you send that via email to the client, then there's usually sufficient time for the client to either say, yes, I agree that that was my services that I expected to have you perform, and you have, and I understand, what you've done on the case, and I understand the time you've shown and the fees that are being incurred and what your proposal to withdraw from the trust account. And sending it by email has the advantage of then getting a faster response from the client, because then if they have questions, if they have concerns, it can be either resolved by further emails, or actually probably a phone conversation or a Zoom conference would be the best if there is some kind of lack of complete approval by the client, to work it out between the attorney and the client, and not have a situation arise where you're breaching the terms of the use of your IELTA trust fund account. Conflicts of interest, again, are another major topic that need to be dealt with between potentially and a client, that can arise due to various scenarios. One of the most common one is usually a plaintiff attorney that is taking a case on a contingent basis, and the client has agreed in writing, which it has to be in that retainer agreement, that the fee will be contingent, and the retainer agreement should set forth the terms for that contingency, the amount, whether fees are to be also repaid to the attorney for bringing the cost of the suit or whatever the litigation is. The situation can arise sometimes where the attorney handling the basis for this client, the plaintiff attorney, may be approached by the opposing counsel, who maybe suggest a fast settlement of the case, and maybe or sell some real estate that was in dispute and that was the subject of the dispute. So the plaintiff attorney may realize that if the sale is delayed, there may be the value of the land may be substantially greater because there's maybe activity in that real estate area, or there's some other upcoming development that the attorney's aware of, and the client is not aware. So then it really is the responsibility ethically of the attorney to talk with the client and say, look, we have an offer. They would like to propose this way to deal with the sale of this real estate. But I must tell you that there is potential other development coming in the area. This price may really not reflect the true value. It may be quite insignificant actually compared to what the value is, and you really may regret taking such a quick settlement just because of the fact that you think this will be cash in hand. But again, it may be the client have financial needs and other compelling circumstances that cause the client to want the case settled as soon as possible. So if that's the case, and the attorney is not successful in persuading the client to settle a case, or even doesn't even discuss the motivation that the attorney-client is aware that this new development's coming and the recovery will be greater if the sale is delayed, there was a clear, obviously, then a conflict of interest between the attorney and the client, and really a breach of ethics. So that's one situation that can arise with real estate. Another common source is where, especially in large cities, where the attorney is formally represented, maybe not the opposing party directly, but someone substantially related to the opposing party, perhaps a family member, perhaps a business partner, and never has disclosed this to his present client. He or she may not have realized it immediately when you've met with your present client, but very soon when you do a conflict check, oh my, that was substantially related to what this situation is. That was this person's cousin or other sibling or business partner, and the client may totally be unaware that you even had an interest in representing a business entity that was in opposition or somewhat adverse to their interests. And the attorney may try to argue in their own mind that, oh, these cases are not really that related, it's unrelated, and I'm really not precluded from representing and going on to represent my present client. And therefore, it really isn't necessary that I relate the history of any prior litigation or prior interests or prior dealings with this other attorney or the former party or the parties in interest. But a good way to really analyze as to whether there is a potential conflict of interest in these circumstances is if there's any reluctance on your part, if you're the attorney in that position, to fully disclose the potential conflict to your client, that should be a red flag right there. If you are uncomfortable in raising these facts and circumstances and having a full and frank discussion with your client and allow the client to make that determination as to whether you are preempted or should be preempted from continuing to represent them, then that is certainly something to consider very strongly and very carefully. And if there is that potential of that much of a conflict of interest and the client does not seem to be as comfortable in having you represent them, or even maybe but not sure, it probably would behoove you to encourage the client to consult with an independent attorney, completely unrelated to any of these litigants or yourself, regarding any potential conflict of interest, and for that attorney independently to document whether or not they feel that you could continue to ethically represent the client, and whether the client indeed is not being manipulated or misrepresented or any way deprived of their own interest in this litigation, and that it is a fair proceeding, and that the client is, after due independent judgment by a third-party attorney, does want to continue working with you. And it may be at that point they've decided they don't, and that you are potentially compromised. And if that's the case, then it would be the duty for you as attorney to withdraw from representation and encourage the client to get the return of their case materials, their file, and seek independent counsel that is not so compromised. Another potential conflict of interest can arise between an attorney and a client, especially when there's contingent fees that are potentially could be where a case could be settled quickly, but not optimally, at least in terms of the final settlement amount. The attorney may know that further litigation could result in a much better and more financially advantageous outcome. And if the attorney is working on a contingent basis, the attorney may certainly be very tempted to strongly encourage that. But the potential conflict there is that the client may indeed be under financial stress, or just emotionally or intellectually. Litigation is difficult. Litigation is stressful. Some clients are not as able to deal with it. They don't want to deal with the discovery process, which can be very onerous. They may not want to have to produce, hundreds of pages of their financial records and years of tax returns or financial records or real estate records. And they may, in their mind, be much better off to accept a more modest settlement, but to be done with litigation and be able to get on with their lives and do whatever they need. Or they may be under some financial constraints too. They may actually need the financial outcome and the settlement to be realized quickly, even if it's less. So when there is that kind of potential conflict of interest, the best thing is to communicate directly with the client, to document any discussions you have directly with the client. And then if it does become apparent, it's still not going to be a situation where either one of you is completely comfortable on how to proceed, that they either, again, consult with a third-party attorney and see whether what you're recommending as a settlement is really in their best interest, and what the client wants. And the third-party attorney may come back and say, the client really wants this, even though it's a smaller settlement, they need this to be funded quickly. They don't want to continue with having you represent them, and perhaps that you need to refer them on to another law firm where there's not that kind of potential complaint. Otherwise, the client may bring a suit, even if they settle for a lesser amount, and complain that it was your decision, the attorney's decision, unless you've documented very well that you did advise against taking the smaller amount, and that was their decision. So again, being very careful about anything that resembles self-dealing, being open with the communications, having a retainer agreement that settles forth very clearly what are your obligations, what are the goals of the litigation, how costs are going to be maintained or advanced, and that is all to be set forth in the retainer agreement. Another matter can arise when there's a conflict of interest regarding prior litigation between the other party or the individuals representing the other party. Now, sometimes it's clearly completely inappropriate, whether the opposing party directly was represented by you, and now you're representing unknowingly. You took this new client who actually, has now this complaint against a party that you represented perhaps years ago, but still, it's a conflict of interest, and it may be a closely related opposing party. Some conflict of interest can be waived, but again, only if the client is individually and independently counseled by a third-party attorney to determine if indeed it is the client's best interest that you stay on the case, and the client is objectively making that decision with the advice of their independent third-party attorney that they do want you to continue the representation, and they're documenting that that is their decision. And this can arise more probably with larger law firms, because so many times there's hundreds and hundreds, thousands of cases that have been processed by that firm, and sometimes it's very difficult. They may miss, even with a conflict check, they may miss, the parties may be, business entities may change their names. Certainly with women, there may be married names that don't immediately become apparent that this is really a client that we've represented previously. So for a larger firm, particularly, conflict checks are very, very important. But again, if in good faith, those conflict checks are run regularly, and as soon as there is any intimation that there is that kind of a conflict of interest, that it be dealt with openly, and with the onus being on the law firm to allow the client to make independently that decision, and what the client concludes is really in their best interest. And it may be sometimes that the client, if the conflict arose from a long time ago and they don't really feel like this firm is going to be unfair to them, and in fact, they feel the firm will represent them well, if it's documented, and the conflict could be waived. But again, that requires care. Another significant area that it's very important for potential conflicts of interest is regarding between spouses. There's always a possibility when you're representing two spouses, even if they're both coming into the office for the first time to consult with you regarding some representation, there's always a possibility that there could be a conflict of interest in the future. So it is my practice, generally, when that situation arises, that I send a letter to both clients stating that after consulting with them in the office, hopefully at length, that there does not appear to be any potential conflict of interest. For example, if we're doing estate planning for both of them, or dealing with some other kind of family law issue that involves both of them, perhaps with a stepchild, that something might like that arise in the future. So it's best to set forth in the letter that after due consultation with both of them, that you are not seeing that there is a conflict of interest that would require that you not be able to undertake the representation. But that if some circumstance becomes known to either one of them that would change that calculation, that then each spouse would have the necessity of retaining their own independent counsel. Because once you've represented, even for a short time, both of them, even consulting with both of them, and then it becomes apparent that there would be a conflict to represent both of them, you have to withdraw from both clients. You can't resume and just go on to represent one of them. So many times clients, if both of the clients then seek independent counsel and both conclude that the overall goals can be met by you as the independent attorney, even though you had some relationship in a prior litigation or a prior transaction, that it's waived. But again, you have to make sure that the waiver is written and signed by both clients. And again, if the circumstances change over time where it becomes apparent that this conflict does exist, again, your duty would be withdraw as soon as possible, and that they both get independent attorneys. Another frequent interest as far as conflict of interest can arise when you're drafting documents for both spouses. It may be that one spouse has been previously married and there may be children not from the present marriage. And then it'd be more complicated when you have children of the two spouses from the present marriage. Again, it's better to issue a conflict letter stating that after consulting with both of them, that they have agreed that they wish to treat all the children equitably. And usually that's certainly the best situation, whether they're stepchildren, afterborn children, a child that's adopted, a child from a prior marriage or relationship, that they all be treated equally in terms of division of whatever the estate proceeds are going to be. So if you reach that conclusion after discussion with both of them, and they're both clear on that, again, a conflict letter should be issued. That from our discussions, it does appear that I can represent both of you and all the children involved and the heirs, and that if anything rises in the future where that becomes not true, and one spouse suddenly decides that, no, I don't want to, again, agree to continue to treat all the children equally. I really do want to treat the biological children of my marriage to the spouse, but not their children from another marriage or another relationship. And there's always a possibility also when one spouse has passed away, the surviving spouse could then change the terms of the estate planning to more benefit their biological children than the children from the other spouse. So again, if you set forth clearly that, after discussions, you're both aware that those could be conflicts, and that you have not seeing that after discussions with both of them at the same time, and they're willing to agree also that that is the case, and they sign the waiver of conflict. And also it would state that the circumstances change and the facts change, where later one of them decides that they want to do something that would not probably be sought by the other spouse, that then you as the attorney would have to withdraw completely from representation of both of them, because that would only be a fair thing to do, and they would both have to get independent counsel. Another potential source of conflict may arise in a trust document or a testamentary trust allocating income to the spouses. And this is more common when you're doing a work creating either a irrevocable or irrevocable trust, where you're actually setting forth how assets are to be maintained, whether there's to be more precedence given to the preservation of assets and capital gains, or whether income is to be maximized from the trust assets for one or both spouses. And it may be that if one of the spouses is coming to the marriage with significantly more assets, they may be much more interested in just maintaining and growing the trust resources and the assets subject to the trust, rather than maximizing income, because they may feel that the income being generated that they both share as spouses is completely sufficient, and it's more to the benefit of either any grandchildren or other heirs that the assets be allowed to grow over time, and perhaps a minimal disbursement of trust income be given from the trust. The other spouse that perhaps doesn't have the significant financial resources in their own name may be more likely to want to have more of the assets paid out as income from the trust each year, whether semi-annually or annually, and not so much interested as much in the growth of the trust assets. So again, that's a potential conflict that could be arising between the spouses. If you see that discussion coming up, it's best to be open about it and help them, if possible, to work it out to where you try to maximize both of their differing goals, if they can be reconcilable. And if it seems that there is any kind of dissension, or one spouse tries to approach you to talk to you about it, and maybe not even disclose to the other spouse how much income is being generated or assets are worth, in that case, any intimation of that kind of a discussion, I think as the attorney, you should immediately cease representation and advise to both of them they seek independent counsel, because once that one client is trying to compromise you in that manner, you're really in an impossible situation. Because if you disclose to the spouse, the innocent spouse, that you've been made the subject of this kind of side discussion by their spouse, you're actually violating confidentiality if you make that disclosure without the consent of the spouse that was trying to have you make terms that were to their benefit and their interest. But if you don't disclose it, then you're violating your duty of loyalty and fidelity to the innocent spouse. So in that situation, there is no way to maintain any kind of continued representation. And the only situation that can be dealt with in that manner is that you completely withdraw from representation. I think you certainly would not want to make any disclosures specifically as to why you were withdrawing, because you would be violating the trust of either one or both clients. But just say it has become apparent to me that there are differences and that I perceive a conflict of interest, and I would suggest you both obtain different attorneys, or at least one other new attorney, and see if they perceive it the same way I did. But this is my decision, and I'm going to withdraw from representation. Another area of discrepancy between spouses can be one spouse may have a very different philosophy as to whether and how income streams are to be managed out of a trust. The older spouse may feel it's much more important for the assets to grow over time and not so much just present income, whereas the spouse that has limited financial resources independently and maybe not have been as sophisticated financially may feel that they just want to have the use of more of the income from the trust and not so much growing it over time. There can also be a trust conflict if if charitable organizations are named as successor or potential beneficiaries. There can be differences of values between the spouses, different attitudes to charity, and all those things again need to be dealt with. Guarding confidentiality is another issue that can be very significant regarding attorney-client ethical issues. Communications to be maintained are central, whether you're dealing with a will or a trust. It can be very complex when you're dealing with both spouses, and if one spouse indicates they want to discuss something with you that they don't want you to share with the other spouse, and they may try to minimize it. Oh, it's just a small personal question I have. It's not central really to what you're doing for the will or the trust. But no matter how minor that kind of a disclosure may sound, it really is putting you in a very awkward position as the attorney. And you have to absolutely explain to them that any disclosure that you're telling me that I cannot share with your spouse when I am representing both of you is completely unacceptable. And it's really putting this joint representation at risk. Because always the situation that the spouse that is not aware of this communication may accidentally find out about it, and that would completely destroy the trust they have in you as the attorney, and also probably escalate the tensions between the spouses. There can also be confidentiality issues with respect to third parties. Sometimes it's a little bit easier to deal with because it's a third party that's just demanding they want to know, for example, the elements of the trust agreement or the income of the trust. It may be a creditor, it may be a potential beneficiary of the trust. But in the absence of written communication to the client that they are authorizing such a disclosure, and for what purpose, and if it's not set forth in the trust agreement, then you absolutely would certainly be in the right to tell the third party that you're not authorized to make those disclosures. That's violating your duty as the trustee or the drafter of the trust. And that, especially if it's a creditor, then you could really proceed with extreme caution, because they would be certainly trying to use that information basically to collect trust income to pay their client, the creditor. You're better then to assert your privileged communication. And if they want to go ahead and seek a court proceeding to have a judge weigh as to whether, as the either the drafter of the trust, or if then you're the trustee under the trust, let the court decide as to what are the proper interests of the creditor and the debtor, and what communications must be revealed to the creditor. And with judicial review, even though it's a little more costly, the factors when they're being considered is so much more definitive. And also the court can always seal documents to protect the privacy interests of the parties. Another significant issue that arises in trust work, and also drafting wills certainly, is testamentary capacity. This can arise typically for an aged client, but not always. Sometimes it's a younger client, but sometimes it can be a younger client that either has some psychological impairments, or perhaps physical impairments, or perhaps has used narcotics. And there are questions that either are apparent or become apparent fairly soon that might be some issue of testamentary capacity. And there's various ways to deal with this. One is, which I have used in the past, especially if it's a client that may have some issues of capacity just because of the passage of their age and health, but they still are having sufficient communication skills to understand that you feel that some of the other relatives may object to either the will or the trust that you are creating, that they maybe not have the capacity to understand, and this other relative may feel that they're being not treated fairly under these documents, and because they're going to argue that your client didn't have the capacity to really understand or remember what they should be doing. So the client an easy way to do it, the least expensive, is to have the client just sign a disclosure for the release of his or her medical records from the present treating physician. And if the client is, lucid enough to understand that you're asking them to do that, and they would be comfortable then in having these records released to you, and that could be held as part of their confidential file in the event later that some other family member tries to argue that that will or that trust that they formed, they really didn't have the capacity. But if you have the medical records where the physician, their treating physician, has stated that they do have capacity, they understand the nature of their acts and what they are trying to accomplish in these documents, and they're not doing it under any kind of duress. And that way, you would have sufficient documentation if that argument ever arise that they lack the capacity to enter into the drafting of that will or that creation of that trust. Now this is a more stressful way to deal with it, probably a little less palatable, but sometimes if the client has capacity, but you still feel like they might be subject to such a challenge, is to select a physician who specializes in the assessment of capacity for geriatric or otherwise disabled individuals. And this kind of an expert physician would not be a treating physician. This would be that just their role is as an expert physician assessing capacity, intellectual and physical and all other kinds of disability. And they would write a report giving their assessment of the testamentary capacity of the client. And this could be maintained confidentially by you as the attorney, unless it was ever needed later in some kind of either a probate proceeding, an effort to declare the client incompetent, or after the client's death, if they tried to attack the will on the argument that the client lacked testamentary capacity at the time they entered into those documents. This would be very powerful evidence. And I actually, it was a physician because I practice here using it with Baylor College of Medicine, and that was one of his specialized areas, was actually assessing the capacity of geriatric and other disabled persons. And he was very, very, not just competent in his area, of course, but he was very thoughtful. He really created a caring environment to sit down, not in my presence and not in the presence of any other attorney or relatives, but he would sit down individually with the client and get a rapport with the client and really seek to understand where the client was, both intellectually and emotionally, and what the client's goals were. And he was very good at drawing people out. He wrote an extensive report. He also did conduct some other psychological exam as the interview went on. But it was a very good mix of both his ability to assess people, to communicate with them, and the client that I had referred for this was very comfortable with him. He liked the physician. I said, and I wasn't present for any of the testing. And I asked him afterward. He said, no, it was fine. He said, he made me very comfortable. And he said, he explained that if, we needed to show, in case some of those other relatives of mine try to argue that I don't know what I'm doing or what I want, I think this will do it. So I got the report back later, and it was very supportive. Of course, there's some decline in cognitive abilities as one ages, but my client certainly had the capacity to understand the nature of the bequests, what he intended as far as his testamentary capacity, who were the object of his affection, what were his goals as far as his family life, and he was very comfortable making all those kind of personalized disclosures to this physician, this expert physician, because of the fact the physician took the time. I think he spent maybe an hour and a half with him, and it was a very good meeting, and that was all that was ever required. And later, there was some intimation from one heir that he was going to try to make some claim that the client had lacked capacity under the will. And well, I said, we have our report, so if you want to go down that road, in discovery, I'm sure you can order me and have that compelled to release it, but that's up to you. And that was it. The person only wanted to see if he could coerce a settlement that he wanted. He certainly did not want to get into litigation to compel the disclosure of those kind of documents. And I think at that point, when he knew there was that kind of expert physician, that was it. So he dropped that claim, and that was the end of it. And the client's wishes were upheld, and the trust documents were actually found to be very valid, and the client's family was very pleased in the end. The client did pass probably about a good 6 or 7 years after I did those documents, but there was no dissension. It met the client's goals. He lived independently till right at the very end, when the last couple months when he was in a care home. But that was it. Another area in this, as far as ethics, is verifying this testamentary capacity again. To prevent fraudulent transfers. And that can arise not only with disabled or aged clients, but it can even be clients that are potentially being defrauded by white-collar criminals. They can be very persuasive. They induce confidence. They get a relationship, a friendship, supposed friendship. Sometimes they're housekeepers. Sometimes they're business people. Sometimes they're business partners. And sometimes these clients that have diminished capacity need protection to the extent that they may even need a trustee or a guardian to protect them from these persons that are trying to cause fraudulent transfers. One of the things that certainly is wise is the measures are recommended by both banks and financial advisors. Be very careful about creating joint accounts that aren't between spouses, or giving any individual the right to sign on an account unless it's a spouse or adult child or really trusted family member who's been part of a long-term relationship. If the bank officers, they're very good about it these days, if they feel that someone's being brought to a bank and doesn't seem right, it's not really a close personal relationship, no one they've ever heard of, sometimes if the bank officer is aware that you as are handling matters for them as their financial advisor and their attorney, then they will at least initiate a discussion as to whether they think that you need to talk with your client and find out more about why they're trying to create these accounts, who's telling them to do these things. It's also wise to pay with credit or personal checks only to known creditors for documented expenses. Tell the clients to resist paying via Zelle or third-party financial agents. Should sensitive financial records allow these fraudsters to get into these accounts and transfer funds, sometimes it's impossible to retrieve them. And to tell the client to be aware of emails that purport to be a financial institution where they haven't initiated the transaction, and then they just have to click on a link to make payments to supposed legitimate creditors. And it's not always elderly people, it's not always disabled people. I've run into some clients in their late 30s that, I guess we're all under pressure of time. And sometimes it really looks like it's, a legitimate inquiry from a bank, or individuals, or businesses you've dealt with. And, they just click on that link. And sometimes it's very, very hard to retrieve whatever funds are being sought once they're dispersed or wired or whatever that is. Tell the client also to hover over email addresses that, may say, from Bank of America, but if you hover over it, it's really Ida at send me money. It's almost that bad with some of their real email addresses. when the situation becomes apparent that the disabled or elderly person is beginning to lack capacity, at that point, sometimes an appointment of a trustee or a guardian to prevent fraudulent transfers can be actually the best route. Now, it's more expensive, obviously, having a guardian appointed by our court or someone acting in that capacity. That's why having a durable power of attorney in place already, where the client, when they had capacity, said that if I ever become either physically or mentally incapacitated, I want my adult child or my grandchild or my spouse or my brother or someone that I know and trust to have a durable power of attorney that can act on my behalf and pay bills and transfer assets and do whatever is necessary to make financial decisions that are in my interest and not in the interest of this third party that's trying to defraud them. Sometimes incompetent clients may need the appointment of a conservator or a guardian, as I mentioned. The downside of that is very expensive. They're appointed by the court. The fees charged are generally quite high. There's really no control then at that point, even for you as the attorney, because the court has appointed that attorney as either a guardian of the person and or a guardian of the person's property. And at that point, there's very little control anymore that is left for the disabled person. So it is much more cost effective to have a durable power of attorney drafted, which is what some states call a financial power of attorney, that sets forth if the point comes when I have some lack of capacity or some diminution in my ability to handle my own affairs, should I then the durable power of attorney would take effect. Not immediately, only if I lose that capacity and certified by two independent physicians. And again, sometimes people get their capacity restored, less likely if the person is quite elderly, but it can happen. But still, it is much more cost effective than relying upon a court-appointed guardian. And also, the benefit too for the client is that they have the choice. They are deciding who, in the event of their incapacity, who do they want to handle their financial affairs? Who do they have the trust in? Who do they feel that would be the best person to take over management of their affairs? And again, you can emphasize to them, this may only need to be on a temporary basis, because sometimes elderly persons, if they're having to undergo surgery and have large amounts of anesthetic given to them, it takes longer for them to recover to the point where they can actually more function and mentally regain much of their capacity. So even for that brief period of time, it really is good to have that kind of durable power of attorney. And the client will also appreciate the fact that they had the choice. Whom did they want to trust? Who did they want to handle their financial affairs? And they also can make the decision as to whether this person just gets reimbursed for their costs, or if it's not a really close family member, then they can actually even provide that some form of compensation be paid to this agent, because acting on someone else's financial benefit that way, it is time consuming. And if it's not a close family member, then perhaps it would be fairer for them to receive some form of compensation. Another area to deal with is the common area of unauthorized practice of law. And this is becoming more and more a prevalent topic. And it can arise in a couple of different occasions. Sometimes it's actually a friend or a relative of the client. And maybe the client really doesn't have a close relationship with any attorneys and doesn't want to necessarily pay attorney's fees, but the well-intentioned friend or relative may take it upon themselves to get forms. Sometimes it's an office supply store, or sometimes online, and tell the older or disabled person that, as the friend, I'll help you, get these documents put together, and we'll just get you to sign everything. And that way you won't have to pay an attorney, and there's going to be no need for that. And these forms can be used, and, and if it's a good friend or a relative, the person that's disabled potentially or elderly may feel that this is fine. I'm saving some money, and these are standard forms, and what's the problem? Well, the problem can be, number one, unwittingly, that well-intentioned but non-attorney, third-party friend or whomever they are is actually engaging in the unauthorized practice of law. Because when they are actually selecting a form, helping the elderly person or disabled person, these are the phrases you need to strike out. These are the clauses we want to make sure in this. This is the kind of form we need to use to do this. They are inadvertently practicing law without a license. Another matter that could arise very unwittingly is a law firm that's perhaps is understaffed and that seeks to minimize paying attorneys as needed to meet all the client demands for financial power of attorney and healthcare directives. So sometimes what the firm will do is allow the paralegals to basically go ahead, select the forms, meet with the client, select the clauses, type up the forms, get someone at the firm to witness their signature. And if that is never reviewed by a staff attorney, that is, again, even though it's in a law firm, that's unauthorized practice of law by those paralegals. Now, there is a new situation arising in Texas, which I'm not sure exactly how this is going to work out, but it is now allowing certification of paralegals to do some routine legal work at a lower fee than an attorney would charge without any supervision by an attorney, either at the firm or elsewhere. But the problem that I foresee with this is that the client may receive, no matter if the paralegal's in total good faith, the paralegal may not realize the consequences of some legal advice they're giving, or the forms that they're choosing, or the completion of those forms, and they may be inadvertently giving incorrect legal advice or incomplete services. And the question would become, I see no reason why the client, if they become aware of this, would not have the ability to sue the paralegal because they have engaged unwittingly, if it's the unauthorized practice of law, or even if Texas does allow this practice of limited legal capacity for services on behalf of licensed paralegals, there's still got to be recourse. And if it damages the client where there's economic loss, I'm not sure if any of these paralegals are going to be insured or required to carry any kind of insurance as we are as attorneys, or whether there should become some kind of limited oversight by a licensed attorney. Indeed, that may even be more practical to protect the paralegal, because if the paralegal has inadvertently given wrong advice, wrong documents, incomplete forms, that could be then subject them certainly to some kind of claim for damages in a civil court. And I'm not sure what the effect would be either if the paralegals work for an entity that only is comprised of paralegals. Would the entity itself then be subject to liability? These are all new and developing questions, but I think it can inadvertently, number one, lead to the unauthorized practice of law if it really goes beyond the scope of what the state bar is approving just in terms of routine forms. But even if it's forms that they should be able to handle and errors are made, there's got to be recourse for those clients. And I'm not sure yet what we have decided or how we've decided that that's going to be addressed. That's a new area. It'll be interesting to see because I'm sure over the next year or two, we will certainly see with the advances that are being made in that area of allowing paralegals to operate so independently. That's got to be a developing area of the law, but I'm quite convinced that the risk of loss is going to have to fall either on the company that the paralegal works for or the paralegal individually. And, that's certainly something if the paralegal is not even aware that potentially they're having that liability, which I probably would not be. And also the clients that they're serving, I don't think they necessarily perceive that they would have very little recourse if it's someone that's not a licensed attorney that has indeed helped them to complete forms that have an effect completely maybe opposite of what they intended, with those transactions. So that's something we'll have to watch over the coming months and years, probably more like months, because it's going fairly quickly. And of course, the other thing that contributes to this is now with the way that documents can be generated with AI, that also is going to lead to paralegals feeling potentially that, well, I've entered the answers to these questions, and this is what the forms, the AI program indicates. This is what way this should be analyzed. And, if they don't have the experience and judgment, hopefully that a licensed attorney would, to realize that maybe they're going way astray with what the client's wishes were and what the document that they're having the client sign, and hopefully, not damage the client's financial interest too much, because some of the documents, especially if you're talking about wills and for an elderly person, or that's somewhat financial physical limitations and mental limitations, they may pass away or have a situation where they have a health crisis and have lost the ability to go ahead and do a new will or redo the documents or financial powers of attorney that may be to their detriment. So again, these are just issues to be aware of, for both lay people to be aware of that may be trying to help a friend, and I certainly understand that, or even the paralegals that are being encouraged to pursue their further training as a paralegal, and feel that they are going ahead to potentially help a client, but it may not be the help that they think it is. So again, I think some more oversight is going to have to be generated, because we can't leave clients in that situation. But all these are new issues that are constantly arising and evolving over time, particularly with estate planning and trust administration. And as we talk, some of the other speakers were talking about the difference between irrevocable and revocable trusts, and knowing the distinction between them and the overall impact that can be had on people's financial lives, and what they hope perhaps was bequest for their future generation and their future heirs. So these are the responsibilities as elder law attorneys and attorneys working in trusts and estate planning that are dealt with. But it's a very gratifying field, and especially when you help people to kind of envision what they want to have achieved with the passage of their assets over time and to their family members. I don't know if there's any questions.
Any questions?